All right, the court is calling. Court is calling 2024 CR 009-218 and 2024 009-219. State versus Marlon Daniels. Can I have parties announced for the record?
Megan Galloway for the state.
And for the defense?
George Sharman on behalf of the defendant in these cases.
All right, and you're Mr. Daniels?
Yes, ma'am.
All right. Mr. Daniels, the court, at the request of your attorney, had a PSI ordered. And Mr. Daniels, we're going to proceed with sentencing. And each of the cause numbers, you entered a plea of guilty, and the punishment is to be assessed at 18 years in the prison. Mr. Daniels, I've had a chance to learn more about your background from your attorney, your military service. And I will tell you, I know that no one, at least I have yet to have someone come before me and say, my intention was to get drunk and go out and hit somebody, or get drunk and drive drunk. Nobody ever intends to drive intoxicated or get to that point, but it happens. And that's why I always try to stress to everybody, please, please, if you're going to be drinking at all, even if you think it's just going to be one drink, it's better just to have a designated driver, right? Okay. And I do appreciate the fact that you entered a plea, that you accepted responsibility by pleading guilty, and that you have not wavered and try to blame something else for this. I do note that you said that you couldn't remember, but you know it's true, and I appreciate that. Sometimes people will say, well, I don't remember what happened, so I'm really not responsible. But you didn't do that. And the fact that you entered a plea, and in each of these cause numbers, you were looking at 20 years. And I always tell people, when people go to jury trial, even when I was a defense attorney or as a prosecutor, I sometimes would have to explain to families, you don't know what 12 people are going to do, right? When you go to jury trial, you don't know. 12 people could say, you know what? This person before me is a military veteran. This person before me hasn't been in trouble. Yes, they did this, but we're not going to give them 18 years. Who knows? A jury may decide to have given you 2 years or 3 or 4 or whatever. You just never know. So for you to accept responsibility, for you to take the 18 years, knowing that by taking these 18 years, there is no appeal because you waive your right to appeal. I think that says a lot, even though I know that the family is in a lot of pain, because when you lose someone and you lose someone this way, it's not expected. So the court is recognizing that you entered pleas of guilty to each cause number, that you accepted responsibility, and you took close to the maximum sentence in each of the cause numbers. With that being said, and cause number 2024 CR 009218, the court will follow your plea bargain agreement as previously stated. When you entered your plea, the court is finding you guilty. The court will sentence you to 18 years in the prison. There's a $2,000 fine. The court will give you credit for any time served, and legally, you're entitled to any time that you have served on this case. This will run concurrent with 2024 CR 009219. I'll request the therapeutic community. The therapeutic community doesn't increase the time that you're in custody. It's merely designed to help you maintain your sobriety, address any type of mental health or substance abuse issues you may have, so that ultimately when you're released from prison, you will maintain your sobriety. And there's an affirmative finding of a deadly weapon.
May I address the court on the matter?
Just one moment.
Yes.
And cause number 2024 CR 009219. The court is finding you guilty. The court will sentence you to 18 years in the prison, give you credit for any time served. There's an affirmative finding of a deadly weapon. This run concurrent with 2024 CR 009218. There is to be restitution of $60 to DPS for testing. And the court will recommend the therapeutic community. There's something you wish to say, counsel?
Yes, on the PSI, it said that he had the combat risen. He did not have combat ribbon. So that was erroneous.
Okay.
Step number two, it shows there were two priors of misdemeanors. There was only one. And if you look at it, it's the same date on each.
Okay. All right. Is there anything else?
That's all we have.
All right, Mr. Daniels. Deputy Laura, if you'll give him his trial court certification.
All right.
All right. Counsel? Counsel.
Yes.
All right, your your client has been removed from the courtroom. Did you review the trial court certification of defendant's rights to appeal with him?
I did.
All right, on the record, the court informed the defendant that by entering the plea, he had waived his right to appeal, so he acknowledged that. I followed the plea bargain agreement. So because I followed his plea bargain agreement and because he's waived his right to appeal, he do not have the court's permission to appeal.
I went over that with him, Judge, so he understands.
All right, thank you. Is there anything else from either side?
Well, Judge, I don't know if Mr. Sherman wanted to bring this to your attention, but because the defendant is going to be in custody, I did see that he filed motions to remove the ignition and the lock. Your motions to.
Yes, she's already signed.
Okay,
Yes, I signed those,
we have no
yes.
objection to that.
All right, thank you.
And then we do have victim impact, but
All right, so who are the people here for victim impact?
there's the father,
Okay,
well, the father and husband of the victims, and then the daughter and sister.
all right, so everyone, just give us a moment. We're gonna have medical check him out to see what's going on. And then if you will be patient, we'll have him brought back out if they say that he can be brought back out. And then you can give your victim impact. So what's going on? Okay. Okay.